To understand just how evil civil asset forfeiture is, let's look at how it is described by the Wex Dictionary from Cornell Law School. As I've already quoted, civil forfeiture is the government seizing property they allege was involved in a crime or criminal activity. The Wex Dictionary goes on. Owners need not ever be arrested or convicted of a crime for their cash, cars, or even real estate to be taken away permanently by the government. The government does not have to charge the property owner with any specific crime in order to seize the property. It must prove only by a preponderance of evidence that the property is legally forfeitable. That's right. Under this perversion of justice, not only can government seize the property of any innocent person, they don't even have to charge you with a crime. This is a blatant violation of the due process clauses of both the 5th and 14th Amendments. The 5th Amendment reads, "No person shall be deprived of life, liberty, or property without due process of law." And the 14th Amendment states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." What's this due process that the 5th and 14th Amendments are talking about? According to the Free Legal Dictionary, due process is an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. If you're wondering why I used the Free Legal Dictionary for this definition rather than the Wex Dictionary I've used in the rest of this article, the answer is simple. The Wex Dictionary does not define the term due process, only how the courts have interpreted over the years. Since in most civil asset forfeiture cases, property is seized in a manner that is not designed to safeguard the legal rights of the individual, the actions of those involved violate due process. How do they get away with such a blatant violation of the Constitution? By charging the property, not the person. Again, from the Wex Legal Dictionary. Such a proceeding is conducted in rem against the property itself, rather than in personam against the owner of the property. For this reason, civil forfeiture case names often appear strange, such as United States versus 8 Rhodesian stone statues, because the property is the defendant. That's right. The government doesn't charge you, but your property, as if it had done something illegal. To show you just how ridiculous this is, the Free Legal Dictionary defines a defendant as the party against which an action is brought. Furthermore, the Free Legal Dictionary defines a party in this context as a person. Yet the government isn't charging a person, but an inanimate object, so there is no party to bring a legal action against. The abuses of civil asset forfeiture continue, since even the burden of proof, the preponderance of evidence, is in fact a fraud. From the Wex Legal Dictionary. Under the preponderance standard, the burden of proof is met when the party with the burden convinces the fact finder that there is a greater than 50% chance that the claim is true. In many of the cases I reviewed, the evidence is nothing more than the word of an officer versus the defendant. For example, in one case, a U.S. citizen or retired Marine was stopped for a minor traffic infringement. When the officer searched the vehicle with the owner's consent, he found over $10,000 in cash. When asked why he had so much cash on him, the person the officer had stopped stated he did not trust banks. However, the officer claimed to believe that the reason the person was carrying so much cash was for illegal activities. It was literally the word of the officer versus the word of the owner, and guess whose word was given more credence? If you guessed the officer, you'd be right. This doesn't even meet the preponderance of evidence standard, since no evidence of criminal activity was discovered by the seizing officer. Without a warrant, an exigent circumstance, or any real probable cause, or even evidence other than the officer's gut, the victim of the traffic stop was robbed of over $10,000. How is this not a violation of the Fourth Amendment's unreasonable search and seizure clause, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." I wish I could say this was an unusual event in America today. Numerous groups fighting civil asset forfeiture list hundreds, if not thousands, of examples of this legalized theft every year. While the officer may not have directly and personally benefited from the crime, his department most likely did, whether because the seizure was made under state law or because of the federal equitable sharing policy. From the victim's point of view, how is this any different than the McMinn County Sheriff's Department simply charging and finding them without any evidence?